The Supreme Court of Appeal in Bloemfontein hearing arguments by AfriForum in an attempt to legalise the display of the 1928 apartheid flag. AfriForum is appealing against the Equality Court order that ruled that gratuitous display of the old national flag constitutes hate speech, unfair discrimination and harassment. Let's take you live to those proceedings.
Introduced on May 31st, 1928. The Foundation holds that any gratuitous display of the old flag constitutes hate speech and harassment prohibited under the Equality Act. A display would be gratuitous if it does not serve any genuine journalistic, academic or artistic purpose in the public interest. AfriForum has articulated an alternate view, that even gratuitous displays of the old flag constitute protected expression under Section 16 of the Constitution, and has indicated that it would oppose any application for an order declaring displays of the flag prohibited. Accordingly, the Foundation has resolved to approach the Equality Court for a declaratory order to the effect that any gratuitous display of the old flag constitutes hate speech and harassment prohibited under Sections 10 and 11 of the Act. Now, if a case was brought against the flag wavers, that would be in the application. In other words, the people that would be cited were those waving the flag. And the complaint would be to say, Mr. Latang would say, I wasn't present at Black Monday, I heard about this, but what you did I think constitutes hate speech, and you must be afforded an opportunity to explain why it is not hate speech. And those people would have been cited and they could have given explanation. And there could be a finding made one way or the other about that particular instance. But that was not the case that was brought. The case that was brought was an abstract one, to say all future displays of this flag must be declared hate speech. Now, as I say, I made earlier mention of my learned friend holding up a draft order in replying argument, because it became apparent that the Act only grants powers of declaratory relief after incident. And so then it dawned on the Foundation that you have to tie this to an incident, and then what was sought changed. In other words, suddenly, in replying argument, the claim is that there must be a declarator about this particular instance. I'd submit firstly that the wording of the first problem with it is one cannot run a hearing in the absence of one of the affected parties. We cannot hear their version of events. The second problem is that if we look at the nature of the Act, it talks about making a declarator in the circumstances of the incident. In other words, not in the abstract. In other words, it says, after holding inquiry, the court may make an appropriate order in the circumstances. It must be the circumstances of that case. And so all the case law, what we find is that there are not abstract findings, there are not declarators that certain words constitute hate speech always. The idea is to pin it down to a particular instance and say this amounts to hate speech. Now, it might be a cautionary tale for others. In other words, others might say, well, if that amounted to hate speech, if John Kolani's article amounted to hate speech, I have some very strong guidance as to whether my article would amount to hate speech. But we don't ban words in the abstract, and we don't ban particular terms in the abstract. For example, Justice, first of all, to draw a distinction, in other words, that case was argued in 2011. As I stated earlier, that case was brought on appeal, the order was abandoned, and the conduct is regulated between the parties via an agreement. That agreement doesn't include anything which binds anyone else. No third party is bound by that agreement. What it does is that it encourages supporters of the ANC and of Mr. Malema not to use songs that are demeaning. I think that's the nature of the order. But there is nothing that binds anyone else. Now, what Judge Lamont does do is to state that it's generally immoral to sing Dibulubunu, and that's a different thing from saying it's unlawful. In other words, it sets out some kind of external standard which says you must recognize that this is a song that can cause pain. That's very different to in advance declaring that all singing of that song amounts to hate speech. And the judgment itself talks about the importance of context. To my mind, there's an enormous difference between singing that song at a rally in a manner that can encourage people to act upon what it calls for, which is to go and kill people on the grounds of their ethnicity, versus, let's say, you had a musical recital where people are singing songs from historical periods. It would be exactly the same words, totally different context, and in the one case, we might say this amounts to hate speech, this meets the threshold requirements, in the other one it doesn't. The other example that I'd like to give, based on a real case, as mentioned in the bundle, is the burning of the new South African flag. Now we can imagine an instance, if it is the case, and the Human Rights Commission make out this argument in their heads of argument, that there is no need to have a complaint against a particular party, that one can say, an incident occurred, we're going to the Equality Court and we want a declaration about that incident. In other words, we won't have audi, we won't hear from the other side. And they say a group of people burnt the new South African flag. And in our view, the reason why that flag was burnt, and it's an objective standard, we don't need to hear their subjective intent, is that they do not believe in the constitutional values that are entrenched in the Constitution, the new South African order. This is a clear case of hate speech. This shows a longing for apartheid. It shows a distaste for democracy. It must be declared. But imagine the scenario where you cite the other side and they give an explanation. And the real case that's mentioned in the papers is that on June 16th, there were plans to have a Youth Day celebration in Kliptown, and they weren't held in Kliptown, they were held in Soweto. And the residents were upset about this, and they burnt the new South African flag in protest. Now, they weren't burning the flag because they have any veneration for apartheid. They were burning their flag in frustration at a particular decision that had been made. And once we have that context, we can say the same type of activity, one might be hate speech and the other one not. We cannot determine in advance. We have to look at the facts of the case. We have to hear from the other side.
Not necessary that there be a list between the parties seeking the party seeking the declaratory order and the respondent, but more fundamentally, on principle, there's a two-stage inquiry in granting a declaratory order if they're not. The first is whether the court must be satisfied that the applicant has an interest in the existing feature or continuing right of obligation. Now, plainly, the Nelson Mandela Foundation, as well as the South African Human Rights Commission, has an interest in an existing feature or right or obligation. That is the first requirement. The second requirement, that the court exercises discretion in deciding whether to refuse or grant the declaratory order so. Now that seems to me is exactly what happened in Kalani. He decided to remove the fact that there was a complaint. The dispute, Mr. Kalani had passed away, and the court made it quite clear, granted a declaratory order. Why? To regulate future conduct of the kind of complaint. So on what basis can it be said that there must be an actual incident or a context, as you argue, where somebody has actually been brought before the Equality Court who has in fact displayed the old flag? On principle, that seems to me to be unnecessary on the basis of the proposition that I just.
Justice, I'd submit that firstly with regard to the Kulani case, we have a clear incident. There's a separate question around mootness on the basis that Mr. Kulani had passed away and be unable to have made an apology. Now, with regards to whether there is a future right, this is the question to be determined. In other words, is what is the right at stake? What we see is that there might be a presumptive right that people are free to say what they can say. In terms of the Constitution, they have free speech rights, but that those rights are limited. In other words, there's an absence of a right under certain conditions, notably hate speech. But to determine in advance whether certain conduct amounts to hate speech cannot be done until we have a particular set of facts before us. So in other words, there isn't a countervailing right. There's an absence of a right that someone may have. They may have a right to wave the old South African flag, and the Human Rights Commission and the Nelson Mandela Foundation give a series of examples where they think people are perfectly free to do it. In other words, their limited cases, the non-gratuitous displays. So if it's done in the name of art, academic inquiry, they say journalistic reasons, the Act talks about fair and accurate reporting. They'll say all of those cases, it's perfectly fine for someone to wave the flag, and they are exercising their rights as they're entitled to. The question is, what's the countervailing right? To say that someone has a right not to be exposed to someone else's hate speech. That would be one of the questions that has to be determined. It might be that you're entitled to punish someone who has acted in accordance without having the right to do so, but that must be done on the facts of the case.
Was the countervailing rights not determined both with Malani and in this case? In other words, whether the infringement of Section 10 in this case, and particularly the right of freedom of expression in Section 16, and didn't the court determine that, and determine that not in the abstract, but based on a certain set of facts, and to regulate conduct of the future. That's what the declarative order seems to me relates to the existing future or contingent right. And if one takes into account the purpose of the Equality Act, then surely the court was entitled to make the declarative order that is dealing in this case.
Well, Justice, it seems astounding that an order could be made in the absence of one of the parties. In other words, with regards to the first order that is made, a declarature is made about a particular instance where the parties to that instance played no role in the litigation whatsoever. And the example that I've given before is with regards to the burning of the South African flag, that if we hear the ex parte version and we hear the audi ultra partem version, we would have different pronouncements as to whether it amounts to hate speech. So to declare something of that significance in the absence of the party who is involved, I cannot think of another instance. I cannot think of any instance in the case law where that happens. And the second case is not, in other words, in Kwalani what happens is that the court says other parties should be guided by this case. In other words, those that were to write articles similar to John Kwalani's now have an indication that their articles might amount to hate speech. But it's not more concrete than that. There's no banning of a particular word to say that you cannot say this phrase, you cannot utter this idea. But there is a signal that is sent out, which is that this counts. And so guide your conduct accordingly. And that has the kinds of deterrence effect that many particular findings will make. But that's very different from an abstract finding that all instances of the use of this word or of this symbol will necessarily amount to hate speech. Now, the appellant's case is that in order for something to amount to hate speech, it must meet the test set out by Kwalani, which in other words, it must amount to the promotion of hatred on a listed ground, and then it can be either inciting harm or that the words themselves are harmful. And we know that harmful is a much higher threshold than hurtful. But it means that every single instance must meet that test. And if there is an instance of flag waving that doesn't meet one of those requirements, then we know that there's a problem, that there's been a ban for conduct that is not unlawful. Now, the particular examples that are provided try and demonstrate this. So we can imagine the anti-apartheid protest case, We have a group of protesters who organize a march, and they're all carrying the 1928 flag. So it's not art, it's not journalism, it's not academic inquiry, it's a protest. And they take the flags and they set them alight. And they say, we denounce apartheid. Now, it's not protected by the proviso. It's also quite obvious to anyone that this particular display is not an endorsement of apartheid. It's not to promote hatred. It's to denounce hatred. But nonetheless would be hit by the order. It would be viewed as a gratuitous display and would amount to hate speech. Now, the appellant doesn't need to list every single possible counterexample. There are 4 which I'll go through, and there are a few others. The point is that if any particular example can arise, where everyone would agree that's going to be declared hate speech, even though it is not hate speech because it doesn't meet the threshold requirements, there is a problem with the order. In other words, the judgment of the Court of Quo in its second order, which bans all public displays that don't meet into the proviso, is overbanning. And that's the problem. That's why there's a problem with making a declaration in advance. Another example is that you could have people using the flag to make a point. They trade on the dominant meaning of the flag. In other words, they say, we think that this flag does symbolize apartheid, and we think apartheid is abhorrent, and we think that you are acting in such a manner. There's a real case from Harvard. So students in a Harvard dormitory hung the Southern flag on their balconies, the Confederate flag. And that flag is viewed by many as deeply offensive and is seen as an endorsement for slavery. And so in protest, other students hung the swastika outside their doors. Not because they endorsed Nazism, but because they wanted to say what you're doing is as bad as endorsing Nazism. They were trading on the ordinary meaning of the swastika to condemn hatred. Now, that use of the symbol wouldn't be protected by the order. It would be viewed as a gratuitous display because it doesn't meet any of the proviso requirements. Similarly in South Africa, if protesters want to say the new South African government is just as bad as the old South African government, and they wave the flag to point that out. And we have the example of the book The New Apartheid, which the cover of that book weaves in the old South African flag and the new South African flag to make that point, to say the new regime is as bad as the old regime. Now that kind of political speech, many people are going to find as deeply offensive, as hurtful. They're going to say, how dare you compare the new South Africa with its wonderful constitution to the regressive, sinister apartheid state. But there's a connection. In other words, the concern is that one of the reasons why these truly abstract findings ought not to be made, why courts ought not to decide that in advance, why they shouldn't have be granting opinions about things in the abstract, is because of these concrete cases, because there may be real cases that emerge. So there's a connection between the two. But it is a different kind of point to point out that these examples of flag waving would not violate the Act. But what the order does is it changes the rules. The order says anything that doesn't meet the proviso requirements is hate speech. And the court says, well, what we could then do is that if you wave the flag, you can come to court and you can only use the defences in the proviso. So
or the Nelson Mandela Foundation, for example, in this case, have brought an application to court without any facts relating to specific wrongdoers. In other words, that A, B, or C were persons who were displaying the flag. Because it seems to me that they would be entitled to do so. because they would be acting firstly in the public interest. And secondly, Kolani makes it clear in paragraph 110 that we must act proactively and preemptively in relation to discrimination. And that, I'm sure you wouldn't tell, would be one of the foundational values of the Constitution.
Just I submit two things. The first is that the Equality Court is a creature of statute. It only has the powers granted to it by the Act. It cannot do things that it is not empowered to do. And the Act is very clear. It says, after an incident has taken place. It may be desirable to have different legislation which allows the court to prognosticate and issue opinions. Ordinarily, however, we think that this is not the domain of courts, that this is the domain of the legislature. That if the legislature wants to make certain pronouncements about certain words and certain symbols, it must do so through a democratic process.
Even though I can see in this instance, I am supposed to need some kind of guidance for the future, because I'm encouraged this by the Act, because the Act says I'm taking into account these guiding principles.
Well, Justice, I'd submit that, first of all, the court doesn't have the power to make any declaration without an incident. It's just not within its domain. One cannot go and approach the court and say...
Well, the AfriForum is at the Supreme Court of Appeals wanting to overturn a decision by the Equality Court regarding the old apartheid South African flag.